but you don't know the procedure, you don't know actually what it is all about. So the small claims court is a division of the magistrate court, and it is created to hear and determine minor civil cases for which the recovery of money is the primary purpose. So for me to say here that it is a division of the magistrate court is just the same as we all know the magistrate sits in the magistrate court. When the magistrate sits over criminal cases, he is addressed as a magistrate. When he is sitting in civil cases, he is the district judge. So when he now sits on the small claims court, he is a judge of the small claims court. So when the issue of this small claims court came on board, then the practice direction came into play, and the Plateau State Small Claims Practice Direction came into operation in November 2022. If you have the practice direction, you can see that in Article 1, Plateau State District Court Law Practice Direction on Small Claims 2022. And the main objective of this Small Claims Court is to make the procedure very easy and for people to have easy access to an informal, inexpensive, and speedy resolution of simple debt recovery dispute in the court. That is in the district court. That is in Article 3, Plateau State Small Claims Court Practice Direction 2022. So as we go on, it will be good for us to know the jurisdiction of the Small Claims Court, because we know that jurisdiction is very fundamental in any case before the court. So jurisdiction, as we all know, is defined broadly as the limit imposed on the power of a validly constituted court to hear and determine issues before persons seeking to avail themselves of its process by reference to the subject matter of the issues or to the person between whom the issues are founded, or to the kind of relief that is being sought. We know that jurisdiction is the authority, it is the power that the court has to decide matters before it. Without jurisdiction, the court cannot hear any matter and impose sanctions on any case that is before the court. So jurisdiction is the pillar upon which the entire case stands. Without that jurisdiction, the court cannot do anything. So from filing of an action before the court, before the small claims court, it means the court has jurisdiction. Because if the court has no jurisdiction, then there will be no point filing any case before the court. So as I have said, jurisdiction is the foundation of any case. And without that jurisdiction, the foundation is already shaking and it is entirely broken. So, jurisdiction is very, very fundamental to the hearing of the matter before the court. That is why I have taken my time to look at the jurisdiction of the Small Claims Court. So the jurisdiction of the Small Claims Court, as with any other court, is dependent on the following. 1, the law establishing the court and the laws governing its procedure. 2, the subject matter of the case, parties before the court, condition precedent to the filing of action, valid service of court process, and the territory where the cause of action arose. Then we start with the law establishing the court and the law governing its procedure. So the Small Claims Court, as I have said earlier, it is a division of the magistrate court. And because it is a division of the magistrate court, it is governed by the Constitution of the Federal Republic of Nigeria, 1999, as amended, the Sheriff and Civil Process Act, Evidence Act 2011, the High Court appeal rules, the magistrate court law and magistrate court civil procedure rules, etc. So when the small claims court came on board, the Honorable Chief Judge of Plateau State, Honorable Justice David Bowman, in exercise of the powers conferred on him by Section 274 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, Section 89, Sub 1, Sub A and B and P, has designated all the magistrate courts in Plateau State as small claims court. So the magistrate sitting as district judge in the small claims court shall have and exercise financial jurisdiction as prescribed for their categories in the English jurisdiction of magistrate in the district court law. Cap 89, Laws of Northern Nigeria, 1963, applicable to Plateau State. So the order is cited as the Small Claims Court Designation Order Number 2, 2024, and it came into force on the 24th day of January 2024. So the subject matter of the case. The subject matter of the case can be divided into two parts: the monetary jurisdiction and the type of claim. The monetary jurisdiction in Plateau State, the monetary jurisdiction of the Small Claims Court is provided for in Article 5, subsection 1, subsection D of the Practice Direction on Small Claims Court. Article 5, subsection 1D, the action may be commenced in the Small Claims Court where the claim is for a liquidated monetary demand in a sum not exceeding 5 million naira, excluding interest and cost. And then Article 10, subsection 1, if at the time the action is commenced, the defendant intends to claim against the claimant a liquidated money demand not exceeding 5 million naira, excluding interest and cost, and which claim arises out of the same transaction or series of transactions, then the defendant shall file a counter claim as in Form SCA 5 in answer to the claim under subsection 2. That is, if at the time the action commenced, the defendant intends to claim against the claimant a liquidated money demand exceeding 5 million naira, but not more than 10 million naira, excluding interest and cost, which is the limit of the general jurisdiction of the district court. So the defendant may file a counter claim in the small claims, in the pending small claims action, by filing Form SCA 5, that is under Article 10, subsection 2. And Article 10, subsection 3 is to the effect that if at the time the action is commenced, the defendant has a counter claim that exceeds the general jurisdiction of the district court, the defendant may file a counter claim in the pending small claims action by filing from SCA 5, provided that any judgment in the defendant's favor shall be limited to the general jurisdiction of the district court. So, as I have said from the beginning, jurisdiction is very fundamental in a case. So the monetary jurisdiction of the small claims court is 5 million. So you cannot go to the small claims court to file anything that is above 5 million. And if you have a counter claim that you want to file in the small claims court, the counter claim should still be within the general jurisdiction of the district court. And Article 10 that I have just mentioned here makes reference that if you want to file your counter claim and it is up to 10 million, you can still file, but it has to be within the jurisdiction of the court. So in other jurisdictions, the jurisdiction of the magistrate court is up to 10 million. So if the jurisdiction of the magistrate court, that is the general jurisdiction of the magistrate court, if it is up to 10 million naira, so even if the complainant files a case of 5 million against you, and you have your counter claim that is above 5 million, you can still file a counter claim before the small claims court. But the claim will have to be within the general jurisdiction of the court. So when we come to our own case on the plateau, the general jurisdiction of the magistrate court is not above 5 million. So there is no how you will find a counter claim of more than 5 million and get it before the court. So if you have your counter claim and you find more than 10 million, be rest assured that what you will get from the court, you will get nothing above that 5 million, except if you are even willing to abandon the excess. So if you file to abandon the excess and you file it in a court of competent jurisdiction. So in summary, what I'm saying about the jurisdiction of the small claims court is that a person who has a claim in excess of the jurisdictional amount prescribed in the practice direction has two options. So if you have your claim, whether it is a counter claim, whether it is the main claim, if you have your claim and the claim is above 5 million, you know that you cannot file it in the district, in the small claims court. You will have to file it in the high court, because even in the magistrate court you cannot file it because their jurisdiction is 5 million. And if it is counter claim, it is the same. You cannot file it outside the jurisdiction of the court. So if you file, the two options you have, you may file it in the small claims court. Since it is a court that will give speedy trial, you can file it if it is above 5 million, but be ready to abandon the excess. And if you are not willing and ready to abandon the excess, then you know that you will go to the high court and file it in the high court, not in the small claims court. So that is the option, the two options that you have. If you want to file a case, you can file it and abandon the excess, or you can go to the high court and then file the case there. Because if you find anything more than 5 million, automatically it is above the jurisdiction of the court. So types of claim before the small claims court. The types of claim before the small claims court: simple debt. You go and file simple debt, money that is just between from 1 naira to that 5 million naira. And also, Article 5 subsection D specify that liquidated money demand. So generally, the term liquidated money demand means an ascertained or specific amount which requires nothing more to be done to determine the extent of the defendant's liability. So it is amount that must be already ascertained. Amount that the judge sees in the claim, it is ascertained, not something that will be arguable. So that is the claim that is supposed to be in the small claims court. Then who are the parties? The parties that are supposed to be in the small claims court. Article 5 subsection 1 states that action may commence in the court where the claimant or one of the claimants resides or carries on business in the state. So if one of the claimants, if you have about 2, 3 or even 10 claimants, as far as one of the claimants resides in the state, then this case is fit to be had on the plateau, in the small claims court in Plateau State. Then defendants or one of the defendants resides or carries on business in the state. So if you have many defendants, if even one resides in the state, the court will still have jurisdiction to hear the case. So we are now going to condition precedent, which is another criteria that it must be fulfilled before the court will hear and determine any case in the small claims court. So a condition precedent is something that must be done or must happen in a particular case before one is entitled to institute an action. And that provision is also made in the practice direction of the small claims court. So Article 5 subsection 1E states that an action may be commenced in the court where the claimant has served on the defendant a letter of demand, as in Form SA1. So that letter of demand is a condition precedent. So the letter of demand by this provision is a condition precedent to the filing of an action at the small claims court, which means when you go to the small claims court registry, you want to file your case in the court. Your case, the registrar will not just accept your case and file your case. You must have shown that you have served on the defendant a letter of demand, and that letter of demand is to the effect that you serve the defendant a letter of demand for him to pay the money, the claim that you want to file in the court. It is when you fail to pay, then you now go back to the court again so that you will now file your claim before the small claims court judge. So Article 6 is the service of a letter of demand on the defendant. It's a criterion that qualifies a claim to be marked as qualified for small claims by the small claims registry. So I will make a brief explanation on this Article 6, because that Article 6 is a condition precedent for marking and payment of filing fees. But that Article 6 erroneously states that where a case satisfies the criteria, that where a case satisfies the criteria in Article 4, but that reference there is a mistake or a typographical error in the practice direction. The reference made to Article 4 has nothing to do with condition precedent. That Article 4 is about how practice direction shall be applied and be observed in the district court. So it is a clerical or drafting error within a procedural instrument. So the clear provision of that section 6 making reference to section 4 should have been making reference to section 5 to Article 5 subsection 1E of the practice direction. We don't have the practice direction that I have. If we have, it will have been more clear. But if you have the practice direction, you check on that Article 6, you will notice that the Article 6 is making reference to Article 4. But when you check the Article 4, you will notice that the reference is not correct. So the proper reference here is Article 5, subsection 1E of the practice direction. So where the court is faced with this type of issue, because magistrates we are here, a lawyer can go through the practice direction. And you know, I have said that letter of demand is a condition precedent before the case will even be filed. So a lawyer can now pick on this section to now argue it before you in the court. So when the court is faced with this issue, the judge, or even if it is a lawyer that has discovered that, the judge or the lawyer should know that it is a clerical error. The judge or the lawyer should apply the law in a way that gives effect to the intention of the practice direction. A drafting error, what I want us to note here is that a drafting error does not invalidate the provision the provision of the practice direction, and the court must interpret it to give effect to its purpose, the purpose of that section. So when you look at that section, what is the intention? What is the intent of that section? You now interpret it according to the purpose of the practice direction. So the judge should not treat the mistaken reference to Article 4. He should treat it as a clerical error and correctly interpret it to be Article 5, subsection E, as pointing to Article 6.4, pending when there will be amendment of this practice direction. And so if it is a lawyer, it is the same thing, because we all know that a drafting error does not invalidate the provision of the law. Yes. So also, for the court to fully hear the case after the service of the letter of command and other things, there must be valid service of court processes, because we know that service of court process is a precondition to the exercise of the jurisdiction of the court. So where there is no valid service, subsequent proceedings will be a nullity, and it is also captured in Article 8 of the practice direction. So it is the service of hearing notice that confers on the court the jurisdictional competence to entertain the matter before it. So we are going to look at the operation of the small claims court. All the key players, the mere existence of the law, including practice direction or the creation of a special court, will not make the court efficient. All the players must be willing and able to work in synergy. The registry is the first contact with litigants, assess the processes at the registry, and is responsible in its coordination. We have the sheriff, we have the magistrate, which is the key player in the small claims court. So, judgment. The judgment of the small claims court. Article 15 sub 1 makes provision for the judge to deliver judgment within 14 days. Within 14 days after hearing evidence. So the judge has only 14 days to deliver judgment. So the judge shall include the court's determination of issues raised in any interlocutory application by any of the parties. So the entire proceedings from filing to judgment shall not exceed 60 days. That is the provision of the practice direction. So from the time you file your case in the small claims court, the hearing of evidence to the conclusion, it is not to exceed 60 days. That is why people that know about the small claims court, they are willing to go and file their cases in the small claims court because they know it will not take time in the court. But there is one thing I want you to know is that if the judgment of the court shall not be invalid by the reason of the entire proceedings of the court having exceeded 60 days. So when the proceedings exceed 60 days, it will not make the judgment to be invalid. Also, Article 16.1 makes provision for enforcement of the judgment. The defendant or defendant a counter-claim shall comply with the judgment and pay the judgment sum within 40 days of delivery of judgment. And any aggrieved party can also go on appeal. So in conclusion, the small claims court, one thing about the small claims court is that it offers new innovations as new ideas are brought to achieve success. It has simplified procedure for filing, presenting evidence, and arguing it easier for individuals to navigate the legal process without even legal representation. So the way it has been prepared, individuals can just go to the court without the services of a lawyer, and then they will file their case and they will prepare judgment. So the starting point, as I have said, once you want to file a case before the court, the starting point, when you go to the court, the registrar of the court will tell you that the starting point is for you to go and serve the defendant with a letter of demand. And that letter of demand is from SCA1, and it is there in the practice direction. It is after serving that letter of demand, then when the defendant refuses to pay, then you still go back to the court, and the court will now give you from SCA2, which is the complaint form, and the summons form is from SCA3. So in the process in the small claims court, there are 8 forms from beginning to the end. And when you go to the court will give you the 8 forms at the same time. And when the court gives you those forms at the same time, you start with the letter of demand. And to make it very easy, very accessible to the general public, the filing fee has been made so flexible that when you go, it will not be issued. So for you to obtain the 8 forms, the money you will pay to obtain those 8 forms is 2,000 naira. 2,000 naira, and then you will get the forms. So when you get the forms, you then work on the forms one after the other till when you will get judgment in the court. So, as you can find subsection 2, the plaintiff, when you want to file your case, the plaintiff is to pay a percentage based on the approved payment for filing as provided by the Plateau State Revenue Board, and the fee that the claimant will pay is just legal. Subsection A of that article 5.2 states that if you are going to pay, because you want to claim 5,000, the filing fee that you pay for that 5,000 is just 750 naira. And if it is from 5,000 to 50,000, you will pay 900 naira. If it is 50,000 to 500,000, is 1,200 that the claimant will pay. And if it is 500,000 to 1 million is still 1,002. But from 1 million to 5 million is 5,002. So making the filing fees low has allowed individuals to pursue claims without incurring significant financial burden. So the court, even the small claims court, encourages the use of ADR, which can help parties reach a mutually agreeable settlement outside of the common cause hearing. So the small claims court is a court that gives speedy trial. Cases doesn't stay long, it doesn't last long in the court. Once you are in the court, within 60 days from the day of filing, from the day you obtain the letter of demand to conclusion, is just 60 days. And I will have to add that it is good we are all aware of this, because sometimes I have seen petitions again from lawyers in cases of small claims court. There was this argument that a lawyer appeared before one of the magistrates, and he kept arguing that the magistrate has no jurisdiction. And the magistrate overruling that he has jurisdiction, the next thing he brought a petition to prolong the case in the court. But the law, the practice direction has already stated clearly that it is just within 60 days and the case will be determined. So if you all know this, you will even help your client so that you will not take the time of the court, you will not waste the time of even your client before the court. And I mentioned earlier from the beginning that the issue of this jurisdiction, there are cases that we have also received. A magistrate will sit down in the court, and when a lawyer makes a motion challenging the jurisdiction of the court, it is expected that you hear the motion and you give your ruling there and then. You either tell the parties that either you have jurisdiction or you don't have jurisdiction. So it is not proper for you to adjourn the case to adjourn deliver the ruling alongside the judgment. The day you deliver judgment, that will be the day you deliver ruling to tell them whether you have jurisdiction or not. So when we do that, it is not proper because you have to settle the issue of jurisdiction before any other action is taken. So thank you for this.
Thank you so much, ma'am. Once again, with a resounding applause, let's appreciate the superintendent the DCR charge of the magistrate court. I'm sure you appreciated the overview she gave concerning the small claims court. Well, I've been directed to inform us that because the topics are quite salient and they're in a class of their own, we will take the question and answer one after the other. So we will not take all of this session before we take questions. So I think it's only proper that now we delve into the question and answer session, and we will minimize that session, please. We will not take so many questions. We'll just take, say, 4 questions. Is that okay, Mr. 4 questions, 5. Yes, the chairman of that committee said we'll take 5 questions, and then my would answer same, and then we'll proceed. So please, if you have questions, can you indicate by the raise of hand? So I have Dr. Mona. Okay, we'll see another hand. Okay, sorry, I don't know if there's another hand here. So I have 1, 2, 3, and the chairman will close the session. You have a question, right? Yes, I will conclude that session. Yeah, do you have another mic for us so that we could, please control that session?